Hello everyone, welcome in. In this video, we will be discussing the Jennifer Crumbley trial with some of my thoughts and opinions. I did wait until the closing of the trial to speak on it because I did not want to present my opinion without having heard all of the facts. I did watch this trial essentially gavel to gavel, maybe missing a few minutes here or there, but I believe I have seen all of the evidence presented, and I definitely have some opinions. I'll give, for anyone who didn't watch the trial but is interested in listening to this video, a quick rundown of essentially the charges and the background of why Jennifer Crumbley found herself in court for the last 7 days, as well as some of the rhetoric that I have seen in the various live chats that I visited and saw on the live streams here on YouTube. There was a handful of different channels and places live streaming this, so I did try to check them all out and see what the general vibe was of the public when it came to this case. So with that being said, my thoughts and opinions are not going to follow the popular thoughts and opinions when it comes to this case. What I saw is most people are, they find the attorney distasteful for the defense for Jennifer Crumbley. They also seem to find Jennifer Crumbley guilty for the charges against her. Now, I started off this case with a bit of wariness because, number one, people have strong opinions on firearms either way, and I did think that might have something to do with this case in general, be it positive or negative. With that being said, the background on the case is Jennifer Crumbley's son did commit a horrible, horrific act, a mass shooting at his school. He ended up murdering 4 people and injuring quite a few others. And he was definitely declining mentally prior to this situation. The charges brought against Jennifer Crumbley are involuntary manslaughter for the death of the 4 students at the hands of her son. A lot of people think Jennifer Crumbley is a bad or negligent parent, but trying to see if that rises to the level of the involuntary manslaughter charges and the foreseeability of this happening. That still is a legal question that is going to be out with the jury starting Monday, possibly and possibly not. I do have a small thought that the judge herself might declare a mistrial before the jury is able to deliberate. I say that because in cross-examination of Jennifer Crumbley, the prosecutor, the male prosecutor, did bring up different affairs that she had had. Now, the defense attorney, in what looks to be strategy, had tried to keep out all information regarding the affairs that Jennifer Crumbley had as parts of the evidence, rightfully so. It appears as though she was attempting to put the state in a trap, and this is all, legal strategy here. She trapped the prosecutors with the admittance and allowing. She opened the door to talking about one of the affairs, a witness that the state had called. So I do believe this was all planned and all actually pretty good legal strategy, in my opinion. From there, since the defense opened the door to that particular affair, the judge was actually pretty clear when arguing about this fact and having to basically get Jennifer Crumbley's sworn statement saying that she is aware of what's going on and that they are allowing evidence that was previously not allowed in. But the judge did say to the prosecutors that this is not the open door to all possible affairs or any hint of affairs that Jennifer Crumbley may have had, only simply the affair with the one witness. Now, in cross-examination, the prosecutor, the male prosecutor, brings up the fact that Jennifer Crumbley had this adult account that seeks out other people, like an adult dating account. I think it's pretty clear it's probably some kind of sexual account. It's to try and have sexual encounters with other people. It's she's obviously not the most, well, I don't want to judge her on her sexual improprieties necessarily, but I don't think she was happy in her marriage and was obviously going outside of her marriage for sexual gratification or for whatever reason it was. But the evidence allowed in was not about that I don't know if it was a website she visited or an app that was on her phone or what, I can't remember exactly, but she had some kind of account on a website that was clearly for cheating on your spouse, or she was married and shouldn't have had that kind of account. And so that was not supposed to be allowed in. Now, the judge didn't do anything when that happened. Now, the judge seemed very intent on not allowing the jury to begin their deliberations, even though she had gotten word from her deputy or whoever it was that said that they would be willing to stay late with the jury so that they could start deliberations. She seemed very apprehensive multiple times to allow the jury to start their deliberations, and then she even did dismiss them and told them to come back 9 o'clock on Monday, giving the jury the whole weekend and not allowing deliberations to begin, which is pretty interesting to me because the judge did seem intent on allowing the jury to go home. It could be possible that the judge has decided that she needs to look into the possible grounds for a mistrial because of the prosecutor putting on record, instances not in evidence in his cross-examination of the defendant herself, okay, and in direct defiance of what the judge had previously stated. So I do believe that obviously there's a record, and you can see on video, I'm going to play right here, the judge clearly stating that this does not open the door to all affairs or everything like that. We do not get to just dig into Jennifer Crumbley's full history of possible improprieties, right? Just the one affair with the witness that you have called as the state. Seems fair, seems logical. But the state did overstep that boundary. So first we will watch the judge actually say, no, this is just a single affair. And then I'm going to show you the moment that the prosecutor brings up this other affair. So real quick, I'll put those in here.
Judge, I think I should make a record so the defendant and perhaps counsel knows for sure. It's not just an affair with one man that was uncovered. There's web searches now. There's trips during work hours. There's when she was on actual work trips with other individuals. It's not just this person. It changes the tenor of the entire trial.
I don't think that that's appropriate. You're asking why this
Judge, counsel has alleged that 2 investigators with 30 years of experience have committed basically a crime by intimidating a witness and lying to a witness, and that it requires a strong and accurate response. This changes the entire case, Judge. I can't let that comment go without being corrected.
Okay, well, I don't know any of this information. You're going to ask him, this witness, why he was protecting her, or why he didn't give full information to the police. We're not going to go off into Never Land and talk about trips or
trips with him, though. Trips with him when she said she was at work or using her son as an excuse to go somewhere. Trips with him in particular, Judge, that goes to the heart of gross negligence and failure to adhere to your parental duty. That is a part of the case that we moved past when the court issued the ruling.
About that.
Your Honor, lots of people have affairs and don't have children that shoot up a school. That's not true.
Again, counsel's now seemingly asking for the same ruling that she had achieved before.
I don't care. I don't care.
I don't know what you're asking me to do because I haven't seen any of this evidence. At the time that I granted the motion to eliminate, I don't even think some of these things were known. So when you say you're opening the door or whatever's happening, I want to be clear on how far the door is open because I also don't want to have this isn't a trial about she isn't charged with being immoral. Okay.
Of course, but she is charged with failure to adhere to her parental duty.
I understand that.
It's going to come out that they had an affair. Okay. It is not because of the affair that Mr. Milosh changed his statement. The first time Mr. Milosh was interviewed, he told them about the affair. The second time he was interviewed, he told them more about the affair. The third time he was interviewed, he told them even more about the affair. That's not his motive for changing his story. his motive for changing his story is because law enforcement put pressure on him and made him fear he'd lose his job.
All right.
It is completely inaccurate. Again,
Okay.
now we have to introduce witnesses.
Okay, I'm not addressing that right now. I'm addressing the now we're going to put in all this information about affairs and all kinds of things that she was spending time with him instead of her son. How far are we taking this? That's what I want to know.
I guess it depends on the questioning.
Okay, well.
Because if that's the record, and if that's the request, and if that is the defendant's wish, Judge, that's fine. But we are going to go through that door with the evidence that we have.
I'm not privy to the information. I don't know what happened. I don't know what the police reports say. I don't know what he said about his relationship with her. Right? I don't know that. But it's also, this is not a trial about her morality, so I want to make sure that we stick to the elements of the case and what you're required to prove, which is not that she's a bad person. That's
Judge,
not what we're here about.
Counsel?
So you told this jury yesterday, you depicted your affair with Mr. Malash as a one time a week meet up at a Costco parking lot. Is that your testimony?
Correct.
Okay. But it wasn't just that, was it?
Nope.
Okay. In fact, there are numerous photographs sent to Mr. Malash.
Okay.
Yes or no?
I'm sure there was.
Okay. Numerous messages exchanged with him.
Correct.
And it wasn't just during the week, Monday through Friday, was it?
No.
No. In fact, that's what you said yesterday. But in fact, it included trips,
There were actual business trips that he met me on.
okay, and it included other individuals.
Yes.
What's Adult Friend Finder?
So where you can go on and meet people who meet certain tastes that you're looking for.
This is 429. And you had the app Adult Friend Finder on your phone.
I do not believe I had the app on my
Okay,
phone.
it was found on your phone.
Okay, well, I guess it was on my phone.
Okay, and there were messages from you to other individuals.
Correct.
Your Honor, I would object that this is going outside of the scope of the affair with Brian, but
I don't think the court's ruling on opening the door was confined to just her extramarital affair with Brian Walsh.
Well, I guess with regard to Mr. Malash, I determined that the defense opened the door. I don't know, but I determined that the defense opened the door as to other relationships.
She depicted herself as having one extramarital affair for about a 6-month period of time, where she met with him one time a week. That was her testimony yesterday. We have evidence to the contrary, and I think it's important.
it's going to get exciting.
All right,
It is what it is.
all right, well, go ahead, but
I won't delve too far
okay, yeah,
into it, Judge.
really, this jury has been here a long time, and
I respect their time, Judge. I'll be brief.
You might not blush.
So, Mrs. Crumbley, I'm sorry, this is not a laughing matter. Mrs. Crumbley,
And so it is just a possibility that the judge might be looking into calling a mistrial because there was a lot of improper instances in this case, a lot of things that were kind of outside the norm of what, at least how most people see a courtroom function and how arguments are supposed to function. Their objections were full of arguments that you're typically not supposed to do because you're supposed to the jury's not supposed to know the nitty gritty behind the argument. You're supposed to state the reason for your objection that is kind of shrouded in the, legal lingo, so to speak, so that the jury doesn't really know why you're arguing because it can prejudice the jury when these are things that both sides have to do. And you don't want that to prejudice the jury, and you don't want them to know really exactly why you are arguing what you're arguing. It can, improperly impact their decision. So I'm not saying that fully rises to the grounds of a mistrial in this case. It just was weird to see these arguments being made in open court, talking about evidence that's not allowed in, or reasons why they've kept evidence out or kept evidence in, and then being able to imply that one side is, maybe trying to hide things or not. Like, the jury is, what are they supposed to think with that? It really depends. Like, when everyone's slinging mud, everyone comes out looking dirty, and that's why that's not supposed to happen. So I do think that I don't want to blame the judge because she was very fair and she was very, she was putting up with like what literally felt like two petulant children as the attorneys. Well, two, like both of the prosecutors and then the single defense attorney. Both the prosecutors clearly had contempt for the defense attorney and for this case, for Jennifer Crumbley, and a lot, I think, rides on them getting a guilty verdict in this case politically. That's just my opinion, but it does seem as though since the community is very angry at the parents, they charged them possibly, right? I say that because I do not think that the state, if I was a juror, met the burden of proof for involuntary manslaughter. Is Jennifer Crumbley a perfect person or mother? No. Should she have maybe seen the signs differently? Yes. Is hindsight always 2020? Yes. And that was a common theme throughout this trial, which is, of course, now everything looks sinister because of what we know. So, a few things that stood out to me as to why I do think that Jennifer Crumbley is not guilty for the crimes that she's been charged with is, number one, I do not think her son was open with his intent to hurt anyone. I think he actually was likely very secretive with his intent to hurt people at all the points up to possibly the math drawing. For those who are aware of the case, he had a journal where he talked about this. He made a video the night before, which was not supposed to be entered as evidence, which, oh yeah, another issue that was also brought up, which is not evidence in this case. So legally speaking, even though obviously it's something that matters, it was kept out. And that was also brought up. So I don't know how that is being allowed. But anyways, he made a video, he did all this. There's no proof that Jennifer Crumbley saw these journal entries, saw the video that he made the night before the act took place. And just to also harp on a few things, I think that the school is very culpable in this as well. If Jennifer Crumbley should have foreseen this, the only people with degrees in psychology or counseling, or the people who are trained with mandatory hours every year or 5 years or whatever it was to see the signs of mental health or mental distress in these teenagers was the professionals from the school in the room, who by all accounts did not find him to be a threat to himself or others enough to, even though the parents didn't take him out of school that day, segregate him from other students. They did not find what I consider a terroristic drawing to be a threat enough to do any action, disciplinary or not. And I find this actually extremely concerning for children in our schools. I'm not a political channel, I am a legal channel. So, all politics aside on firearms, technically, the way the law is right now, you're allowed to own them, you're allowed to buy them, you're allowed to have them. States have different, laws on how you have to store them, but at this time, there was no legal right or rhyme or reason as to how the Crumbleys had to store this weapon. So, taking all politics aside, it just seems as though the professionals in the room, not the parents, but the ones who are trained in threat assessment, should have seen that drawing as a threat. With the newfound prevalence, if anyone wants to call it that, for these school shootings, I do think that it is wise for schools to be on the lookout now more than ever, because people who have the intent to kill will do it by any means if that is their intent, despite their parents' best interests, despite their parents not even owning a weapon, they could still get access to one if they wanted. So I do think that the school, who, by all accounts, number one, the dean of students who was there for this meeting with the parents, who grabbed the backpack from the woman carrying it and commented on how heavy the backpack was and said there was no probable cause to search the backpack. I found that extremely disconcerting, not only for students, but for everyone in this case. Number two, the fact that the school counselor said on the stand that, oh, it was so dangerous for her to have not taken her son home, Jennifer Crumbley, the defendant, that she should have taken her son right then and there. But despite him picking up the vibe, I guess you could say, that they weren't going to take the shooter home, maybe, just maybe, he had grounds to keep the kid in his office or in the nurse's office or something all day if it was that big of a threat and you were that upset and he needed immediate counseling that the parents were somehow, way or another denying. Isn't that what you are there for when the parents fail? So if it is that the parents failed, I do think it is fair that the school failed, which incidentally, they have attempted to have civil suits lodged against the school. But because of, immunity, essentially, it gets thrown out at the district level. They're not able to be sued, despite allowing this student to go back to class with a handgun in his bag that was in the dean of school's possession at one point without searching it. And that disturbing terroristic drawing not being considered a threat to himself or others when it comes to the shooter. I'm very much appalled that we're only holding the parents accountable, the people who've tried, and obviously the families thought that there was some culpability on the school's part, and they were shut down. But we are going to charge the parents for something that they, quote unquote, should have known or seen coming, despite the obvious fact that someone who has intentions to do something bad like this does not tell everyone that they have intentions to do something bad. They take the opportunities. There's a reason why the shooter who made the video that's not is supposed to be in evidence but got talked about outside of the home that night. They have a small house, 900 square feet or something like that. It's not huge. If he was making some kind of ranting and raving video, his parents could have heard him talking about his intentions to shoot up the school the next day. That video was made outside of the home. I find that to be intentional on the shooter's part and showing that there was not negligence, foreseeability, or any kind, it just doesn't rise to the level of these charges for Jennifer Crumbley. I'm only speaking to Jennifer Crumbley right now because there are a different set of circumstances for the husband. I find a lot of their logic to be more emotional than dealing with the actual facts of the case. The defense often was able to get it in there and make it seem as though the evidence was cherry-picked by the state. Now, that's literally what criminal charges are, unless there's something extremely obvious, like we have, at least in my opinion, in the Alexi Treviso case. We got it all on camera, and many attorneys, if you are interested in hearing about how circumstantial evidence is oftentimes way better to convict someone than direct evidence, that's, obviously speaks to the Treviso case, at least in my opinion. But when it comes to emotional cases, which is obviously both the Treviso case and this case, the facts have to also match the charges. And just because it's an emotional thing, and just because the public is mad at someone, the facts have to match the charges. And you cannot find someone guilty just because everyone dislikes them. Otherwise, Alexi Treviso would be in jail right now, right? Because I can name like 2 people who like her, right? Just, I'm being sarcastic, but seriously, if it was off the court of public opinion, then people would be maligned way before they've had a fair and just system judge them. And despite how anyone might feel about certain cases, that is how it goes. And you can assume anyone's guilty. You can say, I think they're guilty, but it will ultimately come down to a jury. In this case, I don't even know if it'll get to the jury, because I have a sneaking suspicion, like I said earlier, that the judge might declare mistrial because of the evidence entered improperly, that people brought up, stuff not in evidence. You're not allowed to talk about these things. The judge literally said you can't do that. And here you are doing that on the last day of trial in front of the defendant on the stand, which, as much as people who, are interested in seeking justice that don't necessarily care about the rights of the defendant, you should, because the more the rights of the defendant are trampled on in the course of getting justice, the more chance they have of an appeal and getting out, right? You want to do it the right way if you really think someone is guilty. And right now, the way I'm seeing it is this was not proper. A lot of rules were broken. A lot of mud was slinged. A lot of, non-professional things happened. And things rising to, at least in my opinion, the level of a mistrial. You cannot talk about evidence you're not allowed to talk about, especially to the defendant themselves. The defendant has a right to not be up there. They don't have to defend themselves. If someone wants to go to trial and plead not guilty, they don't even have to present any exhibits. You don't have to speak. You can do nothing. You can sit silent if you really wanted to, because you could say, "Wow, these facts speak for themselves. I'm not guilty." Right? When it comes to the rights of the defendant, they always, always, always need to be preserved as best as possible, almost to the point of it looking like the defendant is being favored by the judge, because you just want to be that careful. So to enter evidence, to speak about things not in evidence to the defendant themselves on the stand is pretty egregious, right? It rises to the level of a mistrial, at least in my opinion. I would be shocked if the defense attorney is not asking for that, or if the judge isn't willingly herself looking into that, because there were a lot of flubs that happened, and it actually does come down on her shoulders for allowing this to go through like this. I do think she is a good judge. I really like her a lot, and I think she was dealing with in a precedent-setting case and tried to be as calm and personable as she possibly could, trying to appease the jury, because I think that she needed to take a friendly role, because clearly these attorneys hate each other's guts and feel very passionately about either side. And just a note on that, it's a common thread throughout the law world to know that it is much more scary to defend a client that you think is innocent than one you think is guilty. Why? It's obvious, right? If you think this scumbag really did do this horrible crime and you are their defense attorney, you do the best job you can. You obviously give them the best defense possible, but in your heart of hearts, they probably deserve to be in prison anyways, because they did do this shit. You can't actually say that, but they do, right? You can never admit that you think your client is guilty, but in your heart, you can know it. So with that being said, I think that the defense attorney in this case really does feel like these are, trumped up charges, political charges, charges that don't meet the level of proof needed to get the guilty conviction here, and that, her client has already spent a considerable amount of time in jail, and that, she has well served her time, especially if she's found not guilty of these charges. It could possibly even go into malicious prosecution, because there is a lot of stuff that could look like they charged her because people were mad. I know that, that maybe that's just my opinion. That could be, just some speculation here. But if she's found not guilty and they can prove that, there was just a lot of public pressure to press charges, and you knew it was a long, a long shot, but you still paraded this around, then that is basically the definition of malicious prosecution. And the female prosecutor herself even said in her closing statements that, when describing the charges, that she's like, it sounds like a lot to prove. It sounds real hard. And it's like, ooh, yeah, obviously, because it's a pretty high burden. Now, this has to be taken with a completely, non-political opinion on firearms. You just have to, because if you have an opinion on firearms, you're going to automatically think that Jennifer Crumbley's guilty. You're going to automatically see these issues as ones that could have been avoided no matter what, because they should have just never had a gun. Take that away, because everyone in the situation who bought and owned and kept the weapon, by all accounts, this weapon was not kept in the child's room. This weapon was not for the child to use at any other time than with the parents at the gun range. That seems to be corroborated by the shooter's own words in their journal and in text messages to their friend when they send a picture of the gun saying, my dad left it out, and in their journal saying, I have access to it. I'm going to do the shooting. I know I'm going to be able to get the gun now, which leads you to believe that it was not common for that gun to be left out or around. that he noticed a slip up on one of the parents or both of the parents' part as far as leaving the firearm unsecured. Now, an accident of leaving a firearm out is much different than negligence and always leaving a gun around a mentally ill child that you know is mentally ill. At best, the evidence proves that Jennifer Crumbley did and should have known that her son seemed depressed or was depressed. That's the extent of what she thought. Did she give a depressed kid a gun? Did she ignore symptoms? That's all for the jury to decide. And that's for them to decide if that rises to the level of involuntary manslaughter. Now, because there's issues with the foreseeability, in my opinion, that is why I do not think that Jennifer Crumbley should be found guilty of involuntary manslaughter. And I mean that with all the respect to any victims of this case. It is nothing to do with trying to disrespect victims and get her out of any kind of culpability for herself. I think it is a scary precedent to set to say that people should see something that is very likely to be kept a secret by the shooter, that they should have been able to see that coming. Yes, access to a firearm makes it more able for someone to commit a mass shooting, but if you take the amount of children with access to firearms or teens with access to firearms and compare it to the amount of teens or children who commit shootings or school shootings or violent mass shootings of any sort, that is a very low statistic. Many more kids have access to firearms than who take them and use them in a negative and or murderous manner, right? So this is not something anyone can always foresee coming. Do we have red flags? Yes. Was that drawing a huge red flag to me that he should not have been allowed in school or around other students? Yes. One final point of evidence to prove that the shooter was going to try and get away with this in any way possible, in my opinion, was that when asked what the shooter wanted to do, which is also weird to me, because why the hell do you ask a 15-year-old what they want when they just drew this picture on their freaking math paper? Well, what do you want to do? What do you want? Let's make you happy. Well, the mass shooter said that he wanted to be around the other students, that he wanted to go back to class. And we can know now and assume now that that was because in his journal and in his video the night before, he had said, this is going down, this is what I'm going to do. So he needed to get back to the students by any means necessary. We cannot say, should the counselor have kept him in his room the rest of the day? Should the dean have kept him in the office or with the nurse the rest of the day? Or should his parents have taken him home, that it would have changed anything? Would it have happened the next day? Would it have not happened since he was thwarted and not around the students? Would he have said he was trying to go to the bathroom if kept in the counselor's office and went and committed his mass act of violence? We don't know, because no one can tell what's gonna happen until it happens. Very, very rarely do you know exactly when or how someone's mental health is taking effect in formulating such a heinous act. We just don't know. I think it's a dangerous burden to set on parents unless there was direct evidence to show that, that they read that journal, that they knew he was a killer, that they were like, my son is going to commit a mass act and I don't care. I'm getting him a gun. I'm ignoring mental health counseling. The one account from the state's witness that we had, it stood out to me because I was curious, did she care about getting him the counseling or not? Because I did think that that was going to be a big factor for the jury. The state's witness, the co-worker that's not really Jennifer Crumbley's friend, but whatever, just kind of there, I guess, work friendly. She said that when Jennifer Crumbley came back, she said that, quote, we have to get him counseling, her son. She was saying, well, they said we have to get him counseling and we're going to get him counseling. She never said, well, we're never going to get him counseling. That's so stupid of them. He's clearly fine. I don't believe in counseling. Counseling's dumb. I would never get counseling for my son. None of that came out. What she said is, we have to get him counseling. So I do think that she was not ignoring the signs. I think it's fair to say that even though they are the parents who know that there are access to firearms, that the school, who again was attempted to be held accountable by the families and by other people, you know, in this surrounding area and in this situation, who came together to try and sue this school, and independent investigative firms have found severe negligence and culpability on the school's part. But because of immunity, they weren't held accountable. I think that despite parents being a quote unquote expert in their own child, the only expert and ones trained to evaluate, deal with, and mandatory report were the school officials who, in my opinion, didn't do the right thing that day. I think they definitely are trying to cover their own butts when they were on the stand. I think that they were, at least the counselor, had very prepared statements as far as it went to push any kind of culpability for himself, as far as the person who should have and could have seen this coming, who says that he was so concerned that this student not be left alone. But listen to what this student wanted after this drawing, after saying, the thoughts won't stop, there's a firearm, there's blood everywhere on it, like all kinds of crazy stuff on this drawing. You let him go around other kids. Maybe I am not a mental health professional, but that just rings to me as ignorant. I'm sorry. But with the state of school shootings and everything like that, it just seems as though maybe you keep that kid away from other kids. Whether they have access to a firearm or not, that kid's a threat. You don't give the parents the choice to take him. And if they can't take him or won't take him, you do something else. You escalate. Because it seemed as though the counselor and the school officials and what the state wanted to come out was, oh, it was this horrible situation, but only the parents didn't do the right thing. We were begging them to take their son home, but they just wouldn't. They would not take their son home. We begged and begged and begged. Well, if it was that dire and that serious and they wouldn't take their son home and you were begging them, why didn't you call CPS? Why didn't you keep the kid there? Those are the questions that you have to ask, because legally this is a precedent-setting case, and to only hold the parents accountable when the school also had trained professionals who allowed this to slip through the cracks, I find that to be unfair. If I was a juror, I could not find Jennifer Crumbley guilty. I couldn't. I realized that is the vastly unpopular opinion online, that a lot of people, I think at least, I don't mean for this to sound rude, but the people who are hoping for her guilt or think she is guilty are not really well versed in the nuances that it takes to rise to the level of this involuntary manslaughter charge, as well as have possible emotions attached to the charges against this woman, and are hoping for her conviction. Now, I do not blame them for feeling that way, but the facts of the case, at least in my opinion, do not rise to Jennifer Crumbley being guilty of the involuntary manslaughter. If that is the case and you find her guilty, I think that the school should also be held liable. And unfortunately, they're not able to be. But these parents are. So, forgive the reference, but it is the next pound of flesh able to be extracted for the mob that was angry at these obvious, horrific injustices when it comes to what happened at this high school. It's horrible. It's sad. It's tragic. It should never happen. It just shouldn't. There are ways to prevent this. There are. But I do think that the school should have never allowed him to go back around the students, ever. I know students who when I was in school, there were kids with, less than savory parents, with parents that were trashy. Let's just be honest. They were trashy, and it reflected into their student, and unfortunately their student struggled, right? Their kid. And there were times where you'd walk past the school office and kids would be sitting in the office after a disciplinary act, but because they couldn't get picked up, but they're not able to go back to class after you beat someone up or whatever, right? But just because your parents can't come get you, they don't send you to jail, but they do make you sit there and stay in the office. That's a thing, isn't it? Is that not a thing anymore? Am I too old? I don't know, but I'm just shocked that he wasn't made to at least stay in the office. If you guys thought it was that serious, why did you give him the choice to go back to class? Who gives the choice to a possibly suicidal 15-year-old as to what they want to do? What trained mental health professional does that? I find that extremely appalling and sad and scary if you have children, that those are the professionals that are dealing with your children. That is, sorry to sound mean on the school people, but seriously, that is appalling to me and scary that they are trained and that this is how it went panned out. It's just wild to me. It's just wild to me. I think maybe if a student draws a gun with other terroristic things on the paper and they say that they're sad and say all these bad things are happening, maybe, just maybe, those could be automatic grounds for searching a student and their belongings. The dean said that there was not enough probable cause to search the backpack. I find that to be a covering your butt type of thing to say. I think you could probably search that backpack any darn time you wanted. It's usually written into school handbooks that all of your property is able to be searched at any time. That's just how it goes. So to say I had no reason, nothing to believe, aren't you the one who grabbed it and said it was really heavy? It's heavy enough to have a gun and ammunition? Isn't that really heavy? That's not odd to you? And in an odd way, that's just crazy to me. It's crazy to me. Again, these are all my opinions. Please, no one from the school sue me or anything like that, because yeah, these are kind of harsh opinions, but I think they failed. I do. I think a lot of people failed, but do I think anyone else is responsible for the lives that were taken other than the person who took the lives? No. And I think that is a dangerous burden to start setting. Unless you're in a murder for hire, you shouldn't be held responsible for the death of someone else that you did not commit, that you had no intention of, that you had no foreseeable thought or knowledge of, that you were not fully negligent on. I just think it's a precedent that is reaching a bit too far and is an emotional reaction to the obvious crisis that we have as far as mental health with the young students these days, with these young folks. It is not getting better. It is not getting better. And I think we are just trying to deal with it with emotional reactions rather than logic and common sense and what is actually probably right for everyone. Is there a clear path? No. But can we respond with emotions more than logic to situations and expect good outcomes? No, we can't. Because in a roundabout way, and this is the last thing I'll say on this, if Jennifer Crumbley is found guilty, it could possibly set the standard that parents actually become more secretive, more hidden, and more fearful to come forward about any issues or problems with their child. Because should that be on record, you might be held accountable if they ever do anything bad in the future. Let's say you think that they're doing bad. You come forward and say, well, my kid is experiencing delusions. You take them to a counselor. They start getting help for it. You stop going to the counselor when they seem like they're better or are past the phase of weirdness or whatever is going on in their life. And then something bad happens and you stop taking them to a counselor and you look on paper like, oh, well, you weren't doing everything right. There's a whole lot of situations where this can pan out as far as people who shoulda, coulda, woulda known, but can't actually prove that, can be held accountable for actions someone else does. Again, this is not to disregard any of the victims or the lives that were taken, but I do think it is clear whose fault those lives were taken. And I do not think that that person is Jennifer Crumbley. I also think that there is reason for the judge to call a mistrial as far as things not in evidence being talked about by the prosecution themselves. I think it was clever and I think it was strategy on the defense's part to bring in the singular affair. And I think the judge was clear that that was the singular affair to be talked about. And the prosecution still went ahead with that anyways. And that's dangerous. So I do think that it is possible that the judge did not allow the jury to stay for any deliberations and was very pushing for that multiple times. She was like, I guess if you guys want, but I really don't want the jury here. You know, if you guys really want to do it, I don't think it's the time. Are you sure, you guys? I don't think we should have the jury deliberate. I think that was intentional for some reason. And I don't really think it's to give the jury a break. I think she might be looking into the transcript and looking into what actually transpired and saying that this was not a proper trial. That might just be my opinion. Again, I'm just well, I'm said in this video, but for those of you who know me, you know, I'm just a lowly paralegal. These are just my opinions, but I do know a thing or two, and I do think that this trial was kind of handled, as much as I love the judge so much. I really do. I really like this judge. I don't know why, I just do. But as much as I think that she did her best, I think that things got wonky and things slipped out of the reins and it slipped out of line here. And I don't think it was a fair trial to Jennifer Crumbley. Personally, that's just my opinion. But I'm also not a judge. So with all that being said, thank you so much for listening to my thoughts and opinions. If you're another, you know, legal nerd over here and you just found me because you are trying to find stuff about the Crumbley trial, trust me too. I've been trying to watch, look, and listen to anyone giving their thoughts or opinions on this trial as it went, and I was seeing a lack of not only coverage, but, you know, any kind of positive press when it came to the defense in this case. And I don't often have a very differing opinion from the public, but it seems in this one I do. If you're new here, you may not know, but I am always open to comments, questions, concerns, debate. I will never attack you for having a difference of opinion in the comments. I do encourage being told why I'm wrong, because if you do see something different than me, I would love to hear it. I like to see things from all perspective, and I love to evaluate trials and people's thoughts and opinions on those trials, because ultimately they are all the potential jurors. We are all potential jurors. Well, maybe not me because of my legal background. I'm very unlikely to be picked for a jury. So you all are more than likely jurors. And so with these opinions are more, more than valuable to me, because I am coming from a legal standpoint as someone who thinks legally, which is not the case for most viewers of trials. If you're not trained in the law, and you are not someone who is thinking, well, does this really meet the burden? Do we know how to get to the burden of proof on? If you don't know the foundations to get to the burden of proof in this case and the intricacies of that, then you're likely just working off your thoughts and emotions on the evidence like a typical juror. And so that's why I'm, a little fearful, because I see the public having a lot of hate and contempt for the attorney and Jennifer Crumbley herself. And because I'm a legal person over here, I'm worried that maybe I'm one of the only people who sees it this way, because I'm thinking of it legally, not emotionally, not as a layman, so to speak. So if you do have any comments, questions, or concerns, please leave them down below and I'll get back to you as soon as possible. Thank you so much if you've made it this far in this video. If you're interested in following cases like this or the Alexi Treviso case to trial, please subscribe, as I'll be covering that one all along the way with a legal focus. It's your girl Friday. I'll see you in the next video. Okay, bye.